An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
United States v. Windsor, 2013. In the years following Lawrence v. Texas, 2003, several states extended marriage to same-sex couples through judicial decisions, legislation, and popular referendums. Other states amended their own constitutions to prohibit same-sex marriage. This divide created a challenge for federal law. How should the federal government treat a same-sex couple that was married in one state, but then moves to another state where same-sex marriage was not recognized? The Federal Defense of Marriage Act, or DOMA, addressed this problem by providing a single federal definition of marriage: one man and one woman. Under DOMA, it didn't matter where the couple was married or where they lived. DOMA was enacted with broad bipartisan support in 1996, several months after Romer v. Evans was decided. President Clinton signed DOMA into law shortly before the 1996 presidential election. In United States v. Windsor, the Supreme Court considered the constitutionality of Section 3 of DOMA. Because the Obama administration took the position that DOMA was unconstitutional,
the Department of Justice would no longer defend the constitutionality of Section 3.
At that point, the House of Representatives
voted to intervene in the litigation to defend the law.
The House was represented by Paul Clement, the former Solicitor General. During oral argument, the court revisited the debate from Lawrence about whether moral disapproval could serve as a rational basis to treat gays and lesbians differently. A colloquy between Justice Elena Kagan and Paul Clement foreshadowed the outcome in Windsor. Justice Kagan observed that in 1996, the House of Representatives explained that DOMA would
reflect and honor a collective moral judgment
and express
moral disapproval of homosexuality.
She then asked Clement,
"Is that what happened in 1996?
Clement replied,
"Of course the House report says that, and if that's enough to invalidate the statute, then you should invalidate the statute."
He then countered,
"But that's never been your approach, especially under rational basis or even rational basis plus, if that's what you're suggesting."
Current Solicitor General Donald Verrilli declined to defend the law. He argued that there was only one purpose behind DOMA.
The House report makes this glaringly clear, is that DOMA was not enacted for any purpose of uniformity, administration, caution, pausing, any of that. It was enacted to exclude same-sex lawfully married couples from federal benefit regimes based on a conclusion that was driven by moral disapproval.
Chief Justice Roberts interjected.
That was the view of the 84 senators who voted in favor of it and the president who signed it. They were motivated by animus.
In a 5-4 decision, the court would find that Congress and President Clinton, in fact, were motivated by animus. Like in Romer and Lawrence, Justice Kennedy wrote the majority opinion in Windsor. The court found that DOMA's purpose was to
impose a disadvantage, a separate status, and so a stigma upon all who enter into same-sex marriages made lawful by the unquestioned authority of the states.
As a result,
if any state decides to recognize same-sex marriages, those unions will be treated as second-class marriages for purposes of federal law.
Did it matter that Congress could have enacted DOMA to resolve difficult choice of law questions? Justice Kennedy answered, no.
No legitimate purpose overcomes the purpose in effect to disparage and to injure those whom the state, by its marriage laws, sought to protect in personhood and dignity. By seeking to displace this protection and treating those persons as living in marriages less respected than others, Section 3 of DOMA is in violation of the Fifth Amendment.
Did DOMA violate the Due Process Clause of the Fifth Amendment? Or did it violate the equal protection component of the Fifth Amendment? Justice Kennedy suggested that Section 3 of DOMA violated both.
The federal law violates basic due process and equal protection principles.
As in Lawrence a decade earlier, Justice Scalia wrote another vigorous dissent. Once again, he criticized the majority's failure to follow the test from Washington v. Glucksberg, 1997. The court adopted this framework to identify, quote, fundamental rights that are entitled to be protected by heightened scrutiny. He explained that
it is difficult to pin down the precise technical legal basis for the majority's conclusion of unconstitutionality.
the majority did not apply strict scrutiny to protect a fundamental right. Instead, the court took a different approach.
The majority opinion makes clear that what causes DOMA to be unconstitutional is the fact that it is motivated by, quote, the bare desire to harm, close quote, couples in same-sex marriages.
Justice Scalia would
require the most extraordinary evidence
before charging that, quote, Congress and the Presidency of the United States were
unhinged members of a wild-eyed lynch mob.
To the contrary, he contended, there was
perfectly valid justification for this statute. Imagine a pair of women who marry in Albany and then move to Alabama, which does not recognize as valid any marriage of parties of the same sex. When the couple files their next federal tax return, may it be a joint one? Which state's law controls for federal law purposes? The state of celebration, which recognizes marriage? Or their state of domicile, which does not? DOMA avoided all this uncertainty by specifying which marriages would be recognized for federal purposes.
Instead, Justice Scalia observed, the majority saw a very different purpose behind DOMA.
To disparage, injure, degrade, demean, and humiliate our fellow human beings, our fellow citizens who are homosexual.
He concluded,
it is one thing for a society to elect change. It is another for a court of law to impose change by adjudging those who oppose it hostes humani generis, enemies of the human race.
Justice Alito wrote a separate dissent based on Washington v. Glucksberg, 1997. He wrote that, quote, it is beyond dispute that the right to same-sex marriage is not deeply rooted in this nation's history and tradition. Instead, Justice Alito found Windsor and the United States seek, quote, the recognition of a very new right, and they seek this innovation not from a legislative body elected by the people, but from unelected judges. Justice Kennedy stressed that Windsor's
opinion and its holding are confined to those lawful marriages.
In other words, Windsor said nothing about a right to same-sex marriage. Like in Lawrence a decade earlier, Justice Scalia did not believe it.
It takes real cheek for today's majority, as it is going out the door, to leave us with that comforting assurance, when what has preceded is a lengthy lecture on how superior the majority's moral judgment in favor of same-sex marriage is to the Congress's hateful moral judgment against it. By formally declaring anyone opposed to same-sex marriage as an enemy of human decency, the majority arms well every challenger to a state law restricting marriage to its traditional definition.
He concluded,
the court has cheated both sides, robbing the winners of an honest victory and the losers of the peace that comes from a fair defeat. We owed both of them better. I dissent.
Shortly after Windsor was decided, lower courts across the country did as Justice Scalia predicted. They began to rule that prohibitions on same-sex marriage violated the 14th Amendment. In 2015, some 30 years after Bowers v. Hardwick, the Supreme Court decided Burgerfeld v. Hodges. Now, the Constitution was understood to protect a right to same-sex marriage nationwide. In the 3 decades from Bowers to Obergefell, Justice Kennedy wrote each of the major decisions extending the rights of gays and lesbians.